Good morning, everybody. This is Shauna Carpelis here with CA Bar Style. My night was pretty crazy last night, as I'm sure a lot of yours was as well. It is July 28th, the day after the California State Bar, in an unprecedented move, without being too dramatic, released the topics on the essay portion and performance test portion of the California Bar starting this Tuesday, July 2019. I wanted to tune in. I was really riled up last night, super emotional, but I've had some time to get my thoughts together. My voice is a little bit messed up as always when I talk a lot, so bear with me, but I know my thousands of followers who've been emailing me, and I'm sorry if I haven't gone back to everybody, wanting to know my thoughts and what they should do now, people preparing what you should do now. So in the coming weeks and months, we're going to find out a lot about what exactly happened last night. And there's going to be a lot of questions. We definitely deserve answers. And I will have tons of follow-up video and content on my thoughts as a bar tutor in the next coming months. However, that's not the purpose of this video. This video is to reach out to those taking the July 2019 exam on Tuesday. It is Sunday morning on Tuesday, specially focused on my applicants who I've worked with for so many months now, but I do want to put this content out for people maybe that are lost because I care about bar prep, and this is not just about CA Bar Style. It's also about just people that are taking this test, and because I know the stories, I know how much people sacrifice, the thousands of dollars on the courses, including mine, and the registration fees and hotel costs, and now your mind is probably going in a million different places. So let's go through what we know and how to deal with each component for those taking the exam. And this is my cup, but first coffee. And I think that's a good way to start because perspective in life is everything. So we can wake up this morning and be angry, and you have every right to feel those emotions. But if you're taking the bar on Tuesday, you've got to get your mind into a good place. Try and really block out all of the negativity and the rumors and the commentary and the posts and get your head back in the books because you know the topic's coming up now, and I'm going to tell you what to do. Okay, so number one, we're going to block out the drama right now. We're not going to engage with it anymore. We're going to try not to talk about it with our friends and our family. It's a crazy story. Again, we don't have a lot of answers. The State Bar is not giving us a lot. Stop refreshing the State Bar Twitter feed and focus. Get your mind back into a good place. All you need to do is prepare well still. So it's not about what the State Bar did right now. It's not about what that means for your score. It's not about what that means for the grading. You have one job or a couple jobs right now, and the first step is to get your mind back into a good place, to feel good about your prep, and to know that you still have the ability to put this exam behind you, even with all of the drama going on. And as lawyers, I promise you, when you're in trial sometimes, there can be so much chaos. You still, think about a huge publicity or very public trial in the public. You still have to have the ability to focus and get the job done, even with all the static and news and drama around you. So I want you to prove it to yourself right now that this storyline is not going to impact your prep, and you're going to do what you have to do to get the job done. So let's talk about the topics. Number two, we know Civ Pro is coming up. Civ Pro, it could be California, it could be federal, jurisdiction, venue, supplemental jurisdiction, the well-pleaded complaint rule, change of venue, make sure you have a personal jurisdiction approach in there again as well if needed, joinder, preclusion, motion to compel, protective order. To back it up for a moment, in California, they have not gone into subject matter jurisdiction yet. That is the limited, unlimited superior courts in terms of jurisdiction on a state level, even though it's still referred to as SMJ. Make sure you know those rules. Make sure you know all of the pre- and post-trial motions, including a motion to dismiss and summary judgment motion. They like to test those. Make sure you know the rules for appeals and class actions. And that's really the focus of civil procedure. It's pretty clear in the categories that come up there, especially if you're a student of mine, you know what to focus on. For California, I believe I said joinder and preclusion. For California, make sure that anywhere that they have tested traditionally on the federal realm, you're looking at those California distinctions because that is where they have gone with it. Service of process is a big one that was tested in a California scenario. So that could come up again. Make sure you know what is needed to serve properly on a corporation. That does come up. And don't forget, within discovery, they like requests for medical procedures and medical records. Make sure you know how to protect your client there and what relevant information you have to provide. That is it within civil procedure. Now, con law remedies, I did a video very late night last night on this. So, remedies and con law. We could have a call on just the con law aspect, like a free speech, equal protection, even the Dormant Commerce Clause can come up again. We can have the powers of Congress potentially come up, or the executive powers, sovereign immunity, and whether or not you can sue at the state level or an actual governmental entity, when an injunction can be brought, or compensatory damages, freedom of religion, we can procedural due process. Those are all concepts of law within con law that, if violated, could incite the need for injunctive relief. So injunctions is likely your remedy across 99% of constitutional law, and of course the takings clause. So make sure you know how to approach the takings, both a partial and a full taking. February 2010, it was tested, and it's a great essay on the takings clause. Now, for injunctions, if it's a general remedies question, meaning they're asking what remedies, if anything, are available, and it's not just saying, can they get a TRO? Can they get a preliminary injunction? Then you have to go through all three types of injunctions. So a TRO, start with that and the elements for that. Then go into a preliminary injunction and end it with a permanent injunction, full-blown IRAC of elements for each one form of the injunctions. Then don't forget to attach, whether or not they ask for it, any equitable defenses to those injunctions. You will not pass the essay many times because you neglect to put the equitable defenses. So make sure that you know them. Now, crimes, of course, the hot topics are homicide, all forms, first-degree murder. Remember that first can be either premeditation. It can also be felony murder. So you can have murder in the first as that lying in wait, or it can be the felony murder. It's a jurisdictional issue. It's the same elements as felony murder in common law, second-degree murder. So you have everything else being second degree, voluntary manslaughter, involuntary manslaughter, and then common law murder. Don't forget your defenses. Don't forget the imperfect self-defense rule. The insanity defenses have not been tested in a while. Make sure you know all four of those. Make sure you know intoxication, both voluntary and involuntary, self-defense, imperfect self-defense. And those are the main. Homicide, I'm just thinking if I'm forgetting anything. Remember, duress is not a defense to homicide. Those are the main homicide defenses. Know them and attach them to any homicide charge. And remember that if you were not in my course, I do have my full-blown homicide approach up online as well, that you can watch that and it'll help you. In conjunction with that, we have the incomplete crimes of conspiracy, attempt, solicitation, accomplice liability. You could be getting a straight crimes essay in that regard. So make sure you know accessory after the fact as well there. For the rest of crim law, they don't really go into too much. Kidnapping is a hot floater kind of subtopic that likes to come in. You could get an area of a property crime. Don't forget your defenses there, but likely it's one of the other categories that I just mentioned. For criminal procedure, focus on the Fourth Amendment, search and seizure. We know they love that. There's so many essays you can practice for that if you haven't already. Make sure you know confessions and every way to challenge a confession. There are 4 main amendments whereby you can challenge a confession with. Make sure you know pretrial identification and how you can challenge a pretrial ID. It is the same 4 amendments. It's the 4th Amendment, the 5th, the 6th right to counsel, and the 14th. The ID cannot be unnecessarily suggestive. Make sure you know that standard. A lot of applicants do not. And then we have some floater areas like the right against self-incrimination, the right to effective assistance of counsel, and there are some other ones. Just make sure you check your Crim Pro outline for anything else that your tutor or in my course that I pointed out. But those are the main ones. Back up to the 4th Amendment. Don't forget the fruit of the poisonous tree doctrine and the exceptions to that. And don't forget all the different ways that one does or does not have standing that the Supreme Court has held. That reasonable expectation of privacy really does need to be hashed out. And don't forget every possible exception and the way that those work, because those are highly tested areas. Then we get into PR, know all of PR, know all of the duties. Last bar we dealt with a lot of disbarment issues and the unauthorized practice of law. Pay attention primarily, I would say, to the conflicts of interest. There have been many changes in those areas since the changes came out last year for professional responsibility and ethics. Make sure you know PR. Make sure you're creative in your analysis. Don't just say what the attorney did. You have to know your rules and you have to know your distinctions. But you also have to analyze very well on a PR essay. You have to give what the attorney did, what the attorney should have done or could have done. That's where you're going to maximize your analysis points. Don't get me started on how many ethical issues I think came up from last night, but we're going to focus on the bar. Contracts, that's fair game. Really can't go over an entire subject of contracts. For those in my class, you know it's an entire contracts approach. A lot of people have been purchasing my contracts approach. I'll try and get access to everyone that has. If not, I'll just give a refund. It's 2 days before the bar. We did not think that anyone would be purchasing videos right now. But contracts came up the last time on a UCC format. So common law is a little bit more likely. You still will attach your damages, even though it's not a full-blown remedies contracts question, or I would say contracts remedies. So make sure you still touch upon expectation damages, separate IRAC, consequential reliance, incidental, unjust enrichment. But we're probably not going to get a specific performance essay or to set contracts remedies. So you're looking more at that applicable law, then going into formation. Don't forget with applicable law, you have the predominant factor test to consider initially. Then you go into formation, look to the facts. Do they say valid contract, written contract? If they do, just touch upon formation, statute of frauds, establish that quickly, and then get into more of whether or not the terms of the initial agreement have survived and whether or not there's a modification or a waiver, estoppel, novation, impossibility, impracticability, frustration of purpose issue, anticipatory repudiation issue, and then of course breach and damages. If the facts do not say that there's a valid contract, then you're in a full-blown formation essay, and you have to consider all of the latter issues I just mentioned and first establish offer, acceptance, and consideration. Full-blown, as I taught you in my class, the offer should be organized per communication. That makes it very clear. Maybe the first communication is merely an invitation to deal. Somewhere in there you should find an offer. Excuse me, I'm just going to take a sip of coffee. If you do not, never stop. You will keep going. But if you can't find the offer, which sometimes happens, still go into acceptance. Watch out for the mirror image rule there. And make sure, of course, you know the UCC distinction there, although I do think it's going to be more of a common law essay. And then get into consideration. Be on the lookout, especially if offer wasn't met, for promissory estoppel. Regardless, we always will consider promissory estoppel. And if you, in essence, cannot form the agreement, quasi-contract is your issue. So you want to argue that in equity, the formation should still stand because of the actions and performance of the parties. So be on the lookout for those issues. If it's a formation essay, then you'll go into the defenses to the formation. I believe we may have a contracts approach up on YouTube. I'm not 100% sure, but you'll then go into your defenses And of course, we will always go into the statute of frauds, whether or not that contract needs to be in writing, let the graders know. And of course, if it needs to be in writing, tell them why. Whether or not it is, still keep going, and then also list out and IRAC out any other defenses to formation. So that's contracts in a nutshell. Now, to back it up for con law, with such late notice, the State Bar was so gracious. We have to find some humor in this, because if we're walking around with anger and we're pissed off all day about what happened, which again, you have the right to be, we're not going to be able to mentally get through the next couple of days and into the test. So try and laugh a little bit. Con law, just say like, of course my bar, right? How many people? I would have said that. Of course my bar. But con law and remedies, look at July 2009, question 4. In a previous video, I said question 5. Correction there, it's question 4. That is an injunction, somewhat con law cross, so you can get an idea what that looks like now. The performance test evidence memorandum, the objective memorandum. I said this last night, and I was able to pull up and find July 2013 performance test B is an evidence performance test, an objective memorandum. It is very likely analogous to what you're going to see on Tuesday afternoon. It is longer because it was within the 3-hour PT, so it's from 2013. But it's going to look very similar to what you're going to get. It's just going to have shorter content. So the file will be shorter, the library will be shorter. What you want to do there is still keep your format, make sure that you still have IRAC and headings, but it's going to be very similar to what you do on an evidence essay when you're going through relevance and reliability and authentication and all these different standards that the case law or library statutory law gives you to determine whether or not the item of evidence should be admitted into court or should have been admitted. So you could be in a trial setting. Make sure in the case law you're looking at when the item of evidence came in. But the key is it's objective. So your tone, let's say you had a heading relevance, they're giving you law on what relevancy is, and then you're weighing per the task memorandum based on the facts you have, whether or not that item of evidence should come into court in your case. So you want to look at, you could even do a heading under the relevancy rule. You could do plaintiff's position, defendant's position. Discuss the relevancy that the plaintiff's going to argue, give a good analysis there, and then discuss the relevancy that the defendant will argue so that you can balance both sides. Make sure in your conclusion, even though your tone is objective, that you're still reaching a sound conclusion, and because they are looking for the right conclusion, even though it's not a persuasive brief, you are still supposed to give a conclusion that makes sense. So words and adjectives like likely, most likely, probably, that should still be your tone, not definitely or for sure will be, but you want to make sure in your conclusion that you are picking a side. So based on the foregoing, the defendant's relevancy stance is likely to prevail. Something like that is fine, and you can move on, and don't forget a conclusion. But look at July 2013 performance test B, because it is very analogous to what you are likely going to see on your exam Tuesday afternoon. And as a lot of you know that follow me or in my course, you have to pass the PT. So let's just do a regroup here. You're going to focus. You're going to block out the drama. You're going to go through the topics that I just said, and you are going to cover these topics and then be good with them and move on. Don't forget, there's still the multiple choice. You got to be rested. Don't stay up all night tonight and all night Monday night getting all this down. If you were in my course, all of these subjects were on my prediction list. So none of these should be such a surprise. We're just going to thank the State Bar for going, you're already confirming what my tutor Shauna told me. If you weren't in my course, you probably looked at most of these already, because the last couple of days you probably spent on some non-MBE subjects like wills or trusts or agency corporation. So also see it as a blessing that now you know what you can focus on. Do your very best. I'll be around the next couple of days for any questions. I hope this video was helpful. And at the end of the day, without getting too mushy, everything is meant to be. So try and gain some perspective here. Keep your game face on. Don't let anybody distract you. If you're in my course, I'm your distraction. Come to me and I'll answer the question that you have. I wish you all the very best of luck. It's been quite an evening and morning, but it's all going to be fine. Just go and do your job. Good luck, and I will speak to you all soon.